Why in the world would any prosecutor, anywhere in this nation at any time ask a witness whether Jeffrey Williams was there? Nobody would say he was there. Nobody asked him to come. I'm moving for a mistrial on Mr. Williams.
Mr. Chair, I'm going to overrule your motion for a mistrial.
This is a RICO case where the constitutional violations of one defendant affect all the rest of us. We are linked together. We sink and swim together in many ways. I am, too, moving for a mistrial.
All of this is the state of Georgia getting out a theory that is not based in fact, but it has gone so south, I can't do anything. Those are all my objections. I'm moving for a mistrial. This is not the first time that the prosecutors have put themselves in as giving facts before the jury rather than just trying to obtain facts. So I am moving for a mistrial. That's the entirety of this testimony so far. I'm moving for a mistrial on Mr. Williams because this gentleman interviewed a big witness in this event. I don't know how you wipe that out. Are you going to tell the jurors ignore that last comment? That's what you're going to say?
Two pieces of business I have to do, at least for the record. Renew our motion for a mistrial.
Denied. Okay, what else?
Your Honor, I'm going to renew my motion for a mistrial based on coercion by Judge Glanville. It demonstrates the coercion by Judge Glanville, so I'd like you to reconsider that.
All right. I don't think it just demonstrates anything of the sort. I think it demonstrates that he's now been properly advised and he's making a decision anew. Thank you.
It's prejudicial. It's bad character. It's a statement about my client's future dangerousness that the jury has been exposed to. I am moving for a mistrial on behalf of Mr. Stillwell.
It's a bad faith question. It places Mr. Huey's character in issue. There's no basis. There's just no basis for that question to be asked. And because of those reasons, Your Honor, we would respectfully ask this court to grant a mistrial.
I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning that my client has been consistently denied his right to a fair tribunal. I do not believe that this trial should continue, Your Honor.
And I instructed Ms. Persfield to issue an order denying it. If that didn't get filed, I'm sorry, but I'll be denying that.
I just want to make sure that you did see it.
Yeah.
Okay. I would encourage you to grant it, Your Honor.
I'm sure that you would, but I'm denying it.
Discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, do not serve yet. They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator and say, it's not bad faith? Okay. Your Honor, I'm just asking that the rules be enforced.
Number one, we joined the motion for mistrial.
Mr. Kendricks?
Yes. Okay. So I think that needs to be addressed first. And then our motion was in the alternative. If you do not grant that motion, then we have a separate motion. And that's the base of what we contend should be a motion for mistrial. I want a directed verdict of acquittal. The state has not met their burden.
Mm-hmm. I want to remind you guys that I do have a website, www.niquelatnight.com. This is my website right here. I have several things on my website that I would like y'all to take a look at and get perhaps and enjoy. So go to my website and support your girl and clear out this website because I got new stuff that I'm trying to introduce and I need y'all to get on into it. Hey, what's up? It's your girl Nique and you're tuned in to Nique at Night. Now, we oftentimes see shady stuff being done by the prosecution, things that normally would lead to a mistrial, and we even seen an ex parte meeting that led to Brian Steele calling out Judge Glanville, Judge Glanville being mad that he found out about the ex parte meeting. And then there was an attorney by the name of Ashley Merchant who came in to represent Brian Steele when the judge tried to sentence him to 20 days in jail. The judge ended up getting recused, etc., etc. Now, Ashley Merchant, like I said, she goes on an interview with a YouTuber by the name of, I want to say Professor Nez. and she explains about why these mistrials or these motions keep being denied. And I think out of everyone who has talked about these mistrials, she gave the best answer. Okay, so I'm going to show you guys that interview a little bit later. But first, let's refresh everyone's mind about this ex parte that happened that led the judge to get recused, and show you how Ashley Merchant was there standing on business. And then we're going to hear her explanation as to why these mistrial motions have been being denied.
Supposedly in chambers, it's on court reporter at times, on recorded times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on.
Can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that? I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there?
Sir, I'm going to hold you in contempt if you don't tell me who that. Tell me who this information is.
I don't want to be held in contempt.
Well,
I'm not
then
answering that question.
I tell you what, I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. Mr. Williams does not wish to go forward without me being here. You're removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I denied your motion, but I'll certainly take that under advisement, sir. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Attorney Ashley Merchant came to court to represent Brian Steele in this contempt matter.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
And with criminal contempt, I told him what the contempt was, and that was he refused to order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Okay. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
okay. Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge.
If there's a mistrial, does that mean the case will be retrialed? This is a great question. Or is that double jeopardy? If there's a mistrial based on this ex parte with the judge and the prosecutor, it's over. Double jeopardy attaches. It can't be retried because it's not the defendant's fault. It's the fault of the prosecutor and the judge. So it would be over. It would absolutely be over.
All right, so now that your mind has been refreshed from Ashley standing on business in that ex parte meeting, then I inserted a clip from another lawyer by the name of, or his YouTube channel is called Inside the Law. He gave his opinion on why it would have been double jeopardy. Now, let's hear from Ashley Merchant herself as to why there has not been granted a mistrial in this case.
These defendants have fair and impartiality. It's impossible. It's like, to me, it's like trying to unscramble scrambled eggs. Why did she deny? I mean, you tell me, why do you think she denied the motions for mistrial? To me, it seems obvious.
Because. All right. So this is an interview by Professor Nez, and he was interviewing Ashley Merchant. Now, Jeffrey Williams is the big dog that they are trying to get to bring this whole conspiracy together. If they throw out, or if he does not be able to be tried again, their whole case is crumbling as far as this RICO. He is the RICO that they are trying to piece together. So if they don't have Jeffrey Williams and they don't have the ability to try him, there is no RICO. So listen to Ashley Merchant basically explain why she feels the mistrial motions have been denied.
This is the speedy trial demand. I'm convinced that the reason she did so
unpack that. Speedy
yeah,
trial
so
demand.
Jeffrey Williams, who is Brian Steele's client,
AKA Young Thug.
Right. They filed a speedy trial demand. So that's why the case had to go to trial so quickly. So in the state of Georgia, you don't get a speedy trial unless you actually ask for it. So we have a statute that says you have to demand a speedy trial. If you do that demand, they have to try you within 2 terms of court. Okay. So Fulton County, the terms of court are 2 months. So they had to get the jury impaneled, picked, all of that stuff within 2 terms. That's one of the reasons they were kind of hurrying it up, the jury selection, which, I mean, it doesn't seem like it was hurried up, but they did.
Right.
And we had,
I know, it doesn't seem like it.
I know. Well, we had some tolling because of COVID. So there was some, we had some of those statutes were sort of stopped because of COVID. So they had some leniency with that. But essentially they needed to have the jury sworn by a certain date. They got that done, but they don't have any time left. So if this trial goes off the tracks and it's a mistrial, they don't have any time left to retry Jeffrey Williams. So if she had granted a mistrial and she had said it was the state's fault to grant the mistrial, he essentially would have never been able to be tried. And I think that probably weighed into her decision because he's the only one that has that speedy trial. The other folks don't. But if she had granted the mistrial, it would have been really unlikely that the case could have actually gone through in the time that it needed to go. And that, unfortunately, I think had something to do with it,
It seems thank you so much that's why you're here, Ashley. Thank you so much.
Well, and I can tell you one other thing, in my experience is judges don't like to decide stuff if they don't have to. And let me just unpack that a little. If a judge thinks that the defense is winning, they're not as likely to grant a directed verdict or a mistrial or something like that, because it's a lot easier if the jury finds them not guilty. There's no appeals. No appeals. If you get a not guilty verdict, no appeals, and it doesn't fall back on the judge during election cycle, nothing like that. So I've noticed that a lot of times where they think the defense might be winning, they're not as likely to grant these types.
Is there any industry that is devoid of politics?
Oh, no. Right.
Definitely not.
Right, I know.
All right, so to watch the full interview, you can go to Professor Nez's YouTube channel. But I think that her explanation makes the most sense as it pertains to everybody who's wondering, why won't they grant a mistrial? Why won't they grant a mistrial? Why won't they grant a mistrial? In that interview, as she explained, Brian Steele requested for a speedy trial. And if it goes on a mistrial, and that particular mistrial was at fault of the state, meaning it was their fault, then they can't, more than likely, like she said, retry Young Thug again because they had to do it within a certain amount of time. Okay, and we have went well past that certain amount of time, and it would be a wrap for them all the way around. Now, in addition to that, she was specifically talking about like when Judge Whitaker came on and there was all these mistrial motions and she denied them. And then that was her response, because this interview happened like right after that, where they were all asking for mistrials and everything like that. She was saying why she felt like she denied it. Now, in addition to that, I feel like this applies to all the motions of mistrials that have been requested, because all of them have been at severe faults of the state. Each time they're asking for a mistrial, it is something crazy prejudicial that the state has done, crazy purposeful that the state has done, dirty dealings that the state have done, ex partes, all kind of stuff. So I feel like that is a catch-all answer as to why there hasn't been a mistrial period throughout this entire thing. A lot of people were saying, oh, it's because this is the most expensive trial. Oh, it's because, they've already spent all this money on the trial. The money is not coming out of their pockets. What does these judges care about the amount of money spent on this trial when it's not coming out of their pockets, period? So that never set well with me when they were saying that. And when Ashley Merchant explained the speedy trial statute that they have in Georgia, and she said that Jeffrey Williams is the only one that has that, and that's the big dog that they're trying to get, then it all made sense why they're not trying to grant this mistrial, because he is the head of the RICO. And if they can't try the head of the RICO, then they lose all of the other missing pieces. Now, they still can try Shannon Stillwell independently for Nuts murder. They still can try Yak Gotti independently for his role in Nuts murder, and all of the other crimes that they have done, that they have evidence of, and it'll just be individually they'll be able to charge these people. But they want Young Thug to be responsible for these things, because what the state is alleging is that he's the one who called the shots. So if they can't try him, then the RICO isn't really a RICO. I want to remind you guys that I do have a website, www.niquelatnight.com. This is my website right here. I have several things on my website that I would like y'all to take a look at and get perhaps and enjoy. So go to my website and support your girl and clear out this website, because I got new stuff that I'm trying to introduce and I need y'all to get on into it. All right, so I took it to Google to kind of look at this a little bit further. And in my search, I put speedy trial in Georgia after a mistrial. So I was trying to get the terms of that. And as y'all know, they will give you like an AI overview of like what the answer is. And this is what came up. In Georgia, a mistrial does not meet speedy trial requirements if the defendant could have been retried before the term ended. When a case that has a speedy trial demand results in a mistrial, the case must be tried during the next regular court term. In Georgia, a criminal defendant must be tried within the second term of their arrest, but the terms vary by county. A defendant can file a demand for a speedy trial, which sets a strict timeline for the prosecution. If the case isn't tried during the court term it was filed or the next term, the defendant may be eligible for acquittal and discharge. So what I believe Ashley Merchant was basically saying is, listen, we already passed those terms and they barely made that term to bring this situation to trial. Y'all let me know what y'all think about it. And do you think that it's possible that a mistrial will ever be granted? What is it going to take for a mistrial to be granted? Y'all let me know. I think that nothing's going to trigger it. I think that the judge is going to keep on allowing, and this is my opinion, I think that the judge is going to keep on allowing the state to do whatever they do and keep helping them along with their case and let it go to the jury and go from there. And then it's all of the major movement is going to have to happen on appeal if this is not done in a mistrial by the jury or a not guilty verdict. Y'all let me know what y'all think about it. Do you think, like, what do you think is going to take for there to actually be a mistrial, if anything? Okay? Y'all let me know down below and I'll talk to y'all in the next video. I want to remind you guys that I do have a website, www.niquelatnight.com. This is my website right here. I have several things on my website that I would like y'all to take a look at and get perhaps and enjoy. So go to my website and support your girl and clear out this website, because I got new stuff that I'm trying to introduce and I need y'all to get on into it.